But welcome to the Atkinson Speaker Series hosted by the Clinton House Museum. And I'm so excited to have Stacy Leeds and Rebecca Nagle here tonight. I'm going to do a little housekeeping here. First of all, I want to tell you about Dick Atkinson. Stacy, did you have a chance to know him at the law school? You guys, okay, I didn't know if you crossed paths. Okay, well, he was a dear friend of Bill and Hillary's at Yale Law School. Bill Clinton and Hillary Rodham, sorry. I say that as if I know them personally really well. But he went to a law firm in Atlanta after law school at Yale and called up Bill after a year and said, I don't like this. And Bill said, why don't I just get you a job here at the University of Arkansas Law School where Hillary and I are teaching. And so he did. He came here, fell in love with Fayetteville, and spent years then on the faculty at the law school, and he was the dean, and much beloved by students. And I hear his accolades and so many warm emotions from people over the years. So he was actually at the wedding. One of those pictures was showing one of the 12 people at the Clinton wedding. And so we wanted to name this speaker series after him in honor of his public service and his love of politics and history and culture. Right now at the museum, we just opened. We're super excited to have reopened. We've been closed since March 12th. We're open Thursday, Friday, and Saturday from 10 to 5. And we have a new exhibit, a poster exhibit from the Smithsonian called Votes for Women, A Portrait in Persistence. A Portrait of Persistence. We're a private nonprofit organization who's funded in part by the Fayetteville A&P Commission. And we tell a story about Bill and Hillary's early years in politics and careers and early in their marriage. And we try to promote the Clinton legacy of public service and civic engagement, which is one of the reasons we wanted to talk about Native American rights and what's happening in the Supreme Court. That is right up the Clinton alley. And if anybody's having trouble hearing or we can try to help you. We have Hazel Hernandez on here. She's going to manage the chat for me. And I can't promise that we can do anything for you, but we can try. So, okay, I'm going to introduce Stacy and Rebecca. And whatever I say about them isn't going to come close to, like, really, we could just spend an hour and a half going through all of their credentials. So, and I have to just confess, I'm just a huge fan of both of these people, and I don't really know the extent of that, but I am. So Stacy Leeds is the Dean Emeritus and a professor at the University of Arkansas School of Law, and she was the first Native American woman to become a law school dean in the United States. In 2017, she became the inaugural Vice Chancellor for Development at the university. Outside of the law school, and this doesn't even begin to cover all the things outside of law school, Leeds is a justice on the Cherokee Nation Supreme Court and has been a justice for 6 other Native American nations as well. She's published more than 20 articles on Native American legal issues, including tribal courts and government and property issues. In 2016, very impressive, she undertook the 1,000-mile Remember the Removal ride. It's a bike ride from Georgia to Oklahoma that follows the original Trail of Tears path. And of course, that comes right through Fayetteville. And another reason this is an appropriate program for us. Okay, so Rebecca Nagle is also a member, a citizen of the Cherokee Nation. And I'm just going to go ahead and confess, Hazel and I both fell in love with the podcast, This Land. And we geeked out and listened to it together, and we're texting back and forth all the time. And then I found out all the other things she did. And I'm a huge Crooked Media fan too. And so it all, this is kind of a moment for us. I'll just say that. But she's an award-winning advocate and writer who focuses on culture and policy change. And she's currently an apprentice in the Cherokee Nation's Cherokee Language Master Apprentice Program. She's widely published, and you can find her work in many places, including Teen Vogue, Washington Post, Bitch Media, HuffPost, Indian Country Today, Think Progress, the Boston Globe, the Baltimore Sun, and the Women's Media Center. In 2013, Fast Company named her one of the 100 most creative people in the country, and the National Center for American Indian Enterprise Development named her to the 2016 class of 40 Under 40. And her work on that podcast, This Land, garnered her the American Mosaic Journalism Prize in February of this year. So thank you both for being here, and welcome.
Thank you.
Okay, so now that I've done all of the, the necessities here, let's talk about, first of all, both of you, your ties to Fayetteville, and you both have them, and to the Cherokee Nation. And Rebecca, let's start with you.
Yeah, so for people who are unfamiliar with Cherokee history, my ancestors, Major and John Ridge, and some other family members, including Stan Wadey and Elias Bootnan, signed this treaty called the Treaty of New Echota. And it's the treaty that led to our removal. It was a very controversial treaty within the tribe. I believe that they signed it because they felt like it was left with very few options, like the best path forward to preserve our tribe's sovereignty. But it was definitely not the majority of the sentiment of Cherokees at that time. And so at the end of the Trail of Tears, they were both assassinated along with Elias Bootnan. And so like 2 generations of that family were all killed on the same day. And I think what a lot of people don't know, like a lot of times that day gets talked about, but actually over 100 people were killed, both from different factions within Cherokee Nation politics. And I think just, I think the violence of colonialism kind of just boiling up within our own community. And so there were revenge killings and killings back and forth. And so members of my family, like part of the story, like our family cemetery that's still there near Jay, Oklahoma, was started by burying John at night because people were afraid that if they buried him during the day that more people would be killed. And so for a period of time, the family actually fled to Fayetteville and lived in Fayetteville. And so there's the house there that you can go see. Yeah. And so they had brought along with them to Indian Territory, like a school teacher for their children, a white school teacher. And so that schoolhouse was some of the early seeds of the University of Arkansas, which is kind of interesting. So that's my family's connection. They eventually did move back. And that's where like my great-grandfather and my grandmother grew up, was in that area, that kind of corner of Oklahoma. But for a period of time, when there was a lot of violence happening within Cherokee Nation, Fayetteville was a safe haven for that part of my family.
That's really interesting. And for those of you who are from Arkansas or who are near Fayetteville, you may know the Ridge House. It's right across the street from the Walker Stone House on Center Street. And it is the oldest house in Fayetteville. So it's very historic, and it's owned by the Washington County Historical Society, and it's used as offices. It's still in use today. And so it's a real Fayetteville treasure with an amazing story. And so I appreciate you telling us about that. Okay, Stacy, what about you?
Well, first, Angie, I just want to thank you and the Clinton House staff for arranging this event. When Angie got in touch with me with an invitation to participate, it took me all of about 5 seconds to reply. Anytime that I have a chance to have my name associated with Dick Atkinson, although I didn't have a chance to meet him, he served as the dean there at Arkansas, and then Cindy Nance followed Dick. And then I had the honor of relocating to Fayetteville from Lawrence, Kansas. And I became the dean at the law school there in 2011. This academic year will be the 10th year that I've been associated with the University of Arkansas. After stepping down as dean, I took a 3-year position as the vice chancellor for economic development there on campus. And it was very fortuitous that we're getting a chance to connect all these dots today, because July 1 was the day that I stepped down from my position to take a 1-year sabbatical. I had a number of projects that I'd been working on for years that I wanted to close out. One of them being a book about a famous trial that took place in the Cherokee Nation in the late 1890s. And I've been working on it and had about 6 chapters done. And then 8 days into my, what was supposed to be semi-retirement glorious sabbatical, the case that we're going to talk about today came down. And so I had about 1 week's break, and then fast forward into all the things that we'll talk about. When I relocated to Fayetteville to take the job on campus, I bought a house right there on Center Street within a block of the Sarah Ridge House. And so I had known of it for quite some time. But, so many ties of Cherokee Nation and Fayetteville and Cherokee people that were part of the beginning of that city And I think the University of Arkansas is there and as strong as it is today, in part because of that, educated community that was there, many of whom, as you just heard, are Rebecca's family. So my Cherokee connections were always, the Trail of Tears connections were things that I had read about in books and heard stories passed down, but it never really became real to me on a visceral level until 2016, when I did participate in that Remember the Removal bike ride that comes through Fayetteville. And the bike ride was actually the same route that my ancestors were taken on as part of the removal process. And what's interesting about the Trail of Tears is people know about the story of the forced removal process, right? That's what's highlighted in the history books. But there were several different stages of Cherokee Nation's removal. And the first stage, happened after the events that Rebecca describes. And her family was the first family out of the old Cherokee Nation in a period that people call voluntary removal. I think that it's important to realize that no one voluntarily wanted to remove, right? Even those that signed the treaty or were sympathizers with that group, it was as a last resort. And so Rebecca's family was in the first dispatch out of the old Cherokee Nation to Indian Territory. My family was actually on the second group of people. And although my family were not signatories to that treaty that she describes, they were acquaintances and probably of the same political mind. And they were put in a detachment for removal that was actually overseen by a federal officer by the name of B.B. Cannon. And why that's interesting is that it's one of the few detachments where there's a written diary of all the events, where they stayed each night, how far they went each day. But make no bones about it, part of the reason that that military officer was in charge of my family's dispatch was because they were protecting them, right? As Rebecca describes, the people that were of the same political persuasion at the time were probably still under a threat. When it got to the point of the removal process that was truly the forced removal, I think one of the most interesting things is the resiliency of Cherokee people. And when they realized that this was truly going to happen, they wanted to be in charge of their own destiny. So those later detachments were actually headed up by Cherokee men. And a lot fewer percentage of lives were lost in those Cherokee-controlled detachments. But the B.B. Cannon detachment, a treasure trove for historians. But when I went on that ride, each morning we would read a little bit from that diary to talk about what we know about what happened with that group that day. And in the time frame of December 1837, just south of Springfield, Missouri, until the time that they arrived in Cane Hill, it became real to me reading that each day and putting my feet and my fingers on each piece of that land, and Fayetteville included, because our family lost 3 children during that time frame in a matter of 10 days. Many of you on the call that are local historians will know about Ulcie Timberlake, a 12 or 13-year-old girl who is buried in an unmarked grave in Cane Hill. She and 2 of her siblings are in that group of 3. So, that's the Fayetteville connection for me. My family ended up in Fort Gibson, Oklahoma, which is in the western boundary of the current day Cherokee Nation. And my son, who's a 12-year-old, he is the 7th generation of Cherokees born in the new territory. So with that, we've got a lot to talk about, but those are my Fayetteville connections.
We do. Well, thank you both. Okay, well, let's skip ahead, just a couple hundred years. And let's talk about the Supreme Court. And Stacy, why don't we start with you and give us a little overview of the McGirt decision and some of the context history leading up to this big Supreme Court decision this year.
Okay, so the case is called McGirt versus Oklahoma. And it's a case that made its way up to the US Supreme Court out of the Oklahoma Court of Criminal Appeals. In Oklahoma, that's the highest court that hears criminal complaints. And so after the conviction of that case, it went to the Oklahoma Court of Criminal Appeals and then eventually up to the US Supreme Court. The defendant in that case was convicted of a terrible crime. It was a rape and other sex crimes on a very young child who was the victim. And after the conviction, the defendant sought post-conviction relief to have that judgment set aside. And his argument was that he is an Indian person by federal definition, and that Oklahoma had no jurisdiction to prosecute him in the first place. Because that crime happened on the Muskogee Creek Nation Indian Reservation, which is federally set aside for the Muskogee Creek people, and that the crime was therefore subject to federal prosecution by the United States Attorney's Office under the Federal Major Crimes Act and not by the state of Oklahoma. So in July, as I mentioned, the US Supreme Court agreed with the defendant's arguments in this case that Oklahoma no longer has or never had criminal jurisdiction over crimes that are committed by Indians inside the Muskogee Creek Nation boundaries, and that Oklahoma statehood in and of itself did not just evaporate or disestablish those reservation boundaries. So although over time, maybe the ownership patterns of land inside those boundaries changed, but the boundaries themselves, governmental, political, territory boundaries, remained intact. And that was the case from the time the Creeks were removed to Indian Territory, all the way through statehood, and now up to the present day. And so this was a very much awaited 5-4 decision. Justice Gorsuch was the author of this opinion, and he was joined by Ginsburg, Breyer, Sotomayor, and Kagan in the majority. And about a month after the decision came out, the mandate issued, which just means, legal speak for it was carried into effect. And at that time in August, McGirt, the defendant, who's now 71 years old, serving a life sentence, was then transferred out of Oklahoma State Prison, and he now faces federal charges by the US Attorney. So I'll start with an overview of that and let Rebecca pick up a little bit on the Murphy lead up.
Well, let me ask one question before we talk about Murphy. Was the McGirt case just used as like it was a good example, and it's being used like he had to know, he and his attorneys, he's still going to be guilty of this. Why would they try to change the jurisdiction if it was a pretty solid case?
So it will have to be retried in the federal system. Mm-hmm. And so, from his attorney's perspective and from his perspective, that was an appropriate challenge because they believed that Oklahoma was without authority from the get-go. And so what would be required now is a new trial and a subsequent federal prosecution. And so that was the style of that particular case. But there were a number of these cases bubbling up. And so it's not unusual in Indian law cases that an issue that might greatly impact a tribe's sovereignty is brought up and the tribe is not even a party to the case. It comes up in a tax decision, or it comes up in a criminal defendant post-conviction relief type case. So there's significant ramifications for the tribe, but the tribe was not the party that initiated the lawsuit. It's the criminal defendant at issue.
Got you. Okay. So Rebecca, you covered a lot of this, and it's how this all came to my notice through your podcast, was the other case, Murphy v. Sharp, but I've also seen Murphy v. Carpenter, but
and Murphy v. Royal.
okay. So why don't you tell us a little bit about that case, but then also like what attracted you to, like, how do you go from knowing about this case, you're a journalist, and then you end up doing it as a podcast? I mean, that's the whole story, right? Yeah, I can talk about both. So by the time we get to the
verdict, this case is a very, very windy path. And it started in a somewhat unusual place. I think Stacy made a good point that a lot of times these cases that are become about land and treaty rights start somewhere totally different. And so the Murphy case started with a murder in 1999. A citizen of Muskogee Creek Nation murdered a fellow Creek citizen outside of the small community of Vernon, Oklahoma. It was also a very violent crime. Within a year, Patrick Murphy was tried and sentenced to death. And what happened is his federal public defender sort of dug back into the case and found some interesting things, which was actually that the crime may have happened on an allotment, which allotments within Oklahoma are the lands that prior to the McGirt decision, Oklahoma was still acknowledging tribal jurisdiction over, which actually the 10th Circuit had made them do. Right. Oklahoma has a long history of not acknowledging tribal sovereignty where we have those rights. And so the lawyer made that argument. She made the reservation argument, and the case actually has a really long history, it bounced around in state courts and then in federal courts for years. And then in the summer of 2017, the 10th Circuit Court of Appeals ruled that Oklahoma did not have the jurisdiction to convict Patrick Murphy of murder or sentence him to death because the crime did happen on the reservation of Muskogee Creek Nation. Oklahoma, of course, appealed that argument to the Supreme Court, and then that's how the question got to the Supreme Court. And so it was argued in the fall of 2018, and then in the summer of 2019, we were all like anxiously waiting the decision. It was the absolute last decision to be announced that term. We were all on the edge of our seats. And Chief Justice Roberts just like in one sentence just said it has been, rescheduled for re-argument, which basically means that they like punted it down and we're going to decide it next term, which was really confusing to a lot of people. And then what we saw happen the next term is that they took up this McGirt case and, without knowing, because the Supreme Court doesn't publish information like this, but it's, kind of a pretty easy thing to deduct from all of the circumstantial evidence is that because when the Murphy case came up through the 10th Circuit, Justice Gorsuch, he wasn't part of the decision, but he was part of a procedural vote. And so he recused himself, which is very normal within the Supreme Court from the Murphy case. So they only had 8 justices. And so the thinking is that they were stuck probably in a tie vote, and that they took the McGirt decision because, like Stacy explained, it came out of Oklahoma State Court, so Gorsuch could be part of the decision. And then we had a full complement of 9 justices. And like Stacy said also, what happened after Mr. Murphy won in the 10th Circuit is that a number of jailhouse lawyers started filing these different appeals. So it's actually interesting when you look at the court dockets. McGirt isn't the only person, even from the place where he was imprisoned, you see, and they sort of filed them at the same time. And then when you look at sort of the facts of because people were filing them about different reservations, and when you look at the facts of the McGirt case, that it was also about the reservation of Muskogee Creek Nation, you can kind of see the logic of why the Supreme Court decided that would be a case that would be, that would help them settle this larger question that they were looking to answer.
So does it feel then like the McGirt decision does answer the Murphy?
Yeah, so they issued, the same, like it was all online now, so there's no like press room at the Supreme Court with COVID. But yeah, they issued actually, I think pretty much simultaneously online, the order for Murphy and the McGirt decision. And so they will both, like what Stacy explained, they will both be retried in federal court.
Okay, that's interesting. So tell us a little bit about, like, what does this actually mean for Oklahoma residents? Because in all the reading I've done, and you're never supposed to read the comments online, and then I read the comments online, and people are in a couple of op-eds that are really colonial, frankly, in nature. People are really worried about their actual property rights. So Stacy, maybe you can explain to us what it actually means in a practical sense.
Yeah, so a couple of days after the decision came out, I wrote a piece for Slate. And, one of my quotes in that piece was simply, the sun came up in Tulsa just fine, right? And, this was a decision that Oklahoma had a long time to prepare for because of the Murphy dialogue that Rebecca, just described. But I think that they were very shocked about the case because, and I think in good faith, right? I attended a law school in Tulsa, University of Tulsa, and all of the Oklahoma prosecutors and public defenders and the people who came out of that school and the other law schools in Oklahoma, they were just taught that Oklahoma is different and Oklahoma courts have jurisdiction everywhere inside of Indian country, and that there's something just magically different about Oklahoma compared to all the rest of the states across the country that have Indians still living in their, boundaries. And so, I don't think in the modern sense there was anything sinister. It was just the commonly held belief by Oklahomans that they had jurisdiction, except for if you took American Indian law in law school. And then you would know, well, there's this open question, right? And there's an open question that the tribes are very cautious and strategic about raising. That although the tribes have always maintained that they have reservation boundaries and territorial boundaries to the same extent as any other government, Oklahoma and most of the federal decisions up to that point did not agree with that. And so to say that it came as a bombshell to the day-to-day Oklahoman who read this in the paper, it does. They feel like I woke up one day unbeknownst to me and I'm born on an Indian reservation and lived there on my, all my life. And so I think that the mainstream media is partially at fault because there's all these sensational headlines about, half of Oklahoma goes back to the tribes. All it means is that the boundaries, the territorial boundaries, are jurisdictional markers that have legal effect, and that you can't just ignore the law for 120 years and act like something happened that never happened, right? And so if you look at the tribes' constitutions and laws, they will all still refer to their treaty boundaries as the marker of their jurisdiction. And so in federal Indian law, Indian country, or those boundaries, is the place where state jurisdiction stops. And so all it means is that the federal government and not the state, or the tribes and not the state, would be the ones to prosecute Indian defendants when they commit a crime inside of the reservation boundaries. Tribes have been divested of jurisdiction criminally over non-Indians. And so no tribe is going to arrest a non-Indian person and put them in their jail or, try them before the court. And the case was really limited narrowly to criminal jurisdiction in Muskogee Creek Nation, right? Now, it might also lead to similar cases in the other tribes in Oklahoma, but it does absolutely nothing to ownership of land, right? And so, if you look inside the Cherokee Nation, for instance, a tiny fraction of the land is still owned by the tribe, or a bigger piece is owned by Cherokee citizens. I'm sitting in a house in Tahlequah that I own, and I'm a Cherokee citizen, but I still pay property taxes to the state of Oklahoma because those kinds of issues have long since been resolved, right? But the boundary question has always been this question that was, kind of hanging out there. And kudos to the federal public defenders who advanced these arguments in the Murphy case and in other cases. Of course, it was a very scary thing for the tribes to have this case setting in the Supreme Court, because one vote the other way and you get a 5-4 decision, and you get the United States government forever saying that your sovereign rights are diminished and there's no way to bring that back. We know that much. It means a lot to the tribes, but it means very little to the day-to-day Oklahoman who's not a tribal citizen. The only exception is there's provisions in federal law that deal with interracial crimes. And these are outgrowths of treaty provisions and the way that US attorneys policed Indian country in the late 1800s. And so there's a federal law called the General Crimes Act. And the General Crimes Act provides for federal jurisdiction if a non-Indian commits a crime against an Indian person, or vice versa, right? So it was created back during Judge Parker's days, when there was, how do you deal with the non-Indian outlaw who's coming in and out, right? And so, so very, very little change in the day-to-day life of a non-Indian Oklahoman.
Okay, so Rebecca, why don't you talk a little bit about then, I don't want to say from an emotional perspective, but maybe from a civil rights perspective. So legally, we know the day-to-day for the average Oklahoman isn't affected, but this means a lot to the Native American community, right?
Yeah, I mean, I think that the day the decision came out was an emotional day for a lot of Muskogee Creek people, for a lot of Native people in Oklahoma, and I think for Indian country more broadly. I was crying. I think almost everyone I've talked to who, read those first few lines from Justice Gorsuch's opinion, it just brought a lot of people to tears. And I think, over the course of history, tribes have a losing record at the Supreme Court. So we've lost about 2/3 of the time that our treaty rights and our land rights have gone to the Supreme Court. And so the odds are definitely not stacked in our favor. And when we do win at the Supreme Court, I actually think the McGirt case is a really good example where all the law was on our side. There was no, the Supreme Court, Justice Gorsuch, they did not change the law. They did not change precedent. McGirt is not setting new precedent. Simply what Justice Gorsuch did is he took Oklahoma's reasoning that, well, yeah, I mean, these tribes had treaty rights, but come on, for over a century, we haven't really followed them. So you can't expect us to follow them now. And that was basically the gist of Oklahoma's argument. I mean, they tried to couch it in different ways, but that was it. And Justice Gorsuch, in his opinion, said, absolutely not. In no other area of the law would we say, well, Congress passed this law, but the state of Oklahoma decided not to follow it. And they did that for a very long time. So now that law doesn't apply, and he's like, but we treat Indian law differently. We treat treaties as if they are less than any other area of law or any other area of statute. And I think that that's what makes the decision really powerful. What's interesting to me too about the decision, when you really just get into it, the majority of the text he actually spends responding to Oklahoma's argument and the dissent and kind of rejecting all of their logic, which I actually think is going to be a very powerful tool for Native advocates, because that's the logic we see time and time and time again used against our tribes. And so I think that, I think what's frustrating about federal Indian law is that the United States actually did create a framework to divest tribes from our land and our resources. And they did it over and over again. When we talk about our 1866 treaty territory boundaries that we asked the Supreme Court to uphold, there was a lot of loss that got us to those boundaries, right? And even though the United States has created this entire system to divest tribes from land and all of these rules, and which I also think that our ancestors helped create that system and preserve the rights that we have. And so I think it's this compromise that we can't erase our ancestors' involvement in creating. But then the United States doesn't even follow its own rules. Congress never disestablished the reservation of Muskogee Creek Nation, even though it could have, right? And so I think that that's what this victory is symbolic of, is just how big of a deal it is for the courts to follow their own rules, which is also depressingly basic. But I think in federal Indian law, you see courts not do it all the time. And so, and then I think also emotionally, I think as somebody who lives here in Oklahoma, as somebody who sort of, when I think of this land, I think of the sacrifice that my ancestors made. And I think that, this case that is a victory for Muskogee Creek Nation is, we're sort of already starting to see in some of these other court cases, it chart a path to affirm the reservations of the 5 tribes here in Oklahoma. And I think it's also already strengthening the land and treaty rights of tribes across the United States. So we already saw a court decision come out of the 7th Circuit in Wisconsin that cited the McGirt victory. And so I think it is both symbolic and then also legally significant. And at the same time, I think with all of that, we have to underscore that all that Justice Gorsuch did, in his opinion, is read the law and follow it.
Which goes to his reputation as a textualist, right?
Exactly. And a lot of people who say they're a textualist throw the text out the window when it comes to treaty rights. And Gorsuch is somebody who holds that line, which I think, you know, we'll see what his tenure on the court amounts to in terms of Native rights, but we might actually, for one of the first times, have a majority that respects treaty rights. So that could be a big change. That could be a big shift.
Well, for people who may not have heard some of the opening lines of Gorsuch's opinion, I have the first 2 sentences pulled up here. And I have to tell you, I mean, it chokes me up every time I look at it. It's really beautifully written. It says, on the far end of the Trail of Tears was a promise. Forced to leave their ancestral lands in Georgia and Alabama, the Creek Nation received assurances that their new lands in the West would be secure forever. And yeah, the end of the trail is a promise. That's just poetry. And Stacy, I'm sure you've read lots of great legal writing. I don't. And so this old literature professor in me really loved that and appreciated that.
Yeah, the entire opinion is so compassionate and so historically thorough. And I think that when historians look back at this moment, he knew exactly how big of a deal this was going to be. And he knew that that opinion had to be exactly how it ended up. I remember when that case came out, you know, far too much of an Indian law nerd. I follow every, you know, possible thing. I was in the car. We were actually driving out to Colorado to do some hiking. And, you know, bad cell reception, the case came out. I was watching the SCOTUS blog, which is a you know, heavily trafficked legal blog about the United States Supreme Court. And when that decision came out and I hit refreshed and I panned down and I saw who wrote it in that first sentence, and I didn't need to read anything else because I knew what happened. And, you know, it was pretty remarkable. And then the phone just started, you know, ringing, and we've been very, very busy, you know, ever since then. So.
Yeah. Well, I actually saw the decision on Twitter because you texted or you tweeted about it, Stacy, and I'd been kind of waiting for it, but I was going to see it through kind of mainstream New York Times kinds of headlines. And so I actually found out about it because of you on Twitter. Imagine Twitter being good for those things. So, okay, so tell us a little bit about, so Rebecca, you mentioned Wisconsin. What do we anticipate this means for other states, other nations, other tribes? Whoever has a beat on that.
Let me jump on that one. So of course, it answers the question specifically as to the Creek Nation only.
Right.
But there is the conventional wisdom among all of the Indian law scholars and certainly the tribal attorneys here in Oklahoma that we will very quickly, and by quickly I mean court speak, for in a few months, I think that we will see similar decisions relating to the other 4 of the 5 tribes in eastern Oklahoma, so Cherokee, Chickasaw, Seminole, and Choctaw. Those cases are already bubbling up. As I understand it, there's been over 40 cases that were in some state of appeal that were remanded down from the Oklahoma Court of Criminal Appeals to the various district courts. And those district courts are now having evidentiary hearings in those cases to answer 2 very straightforward questions. Is the defendant an Indian under federal law, and did the crime take place in Indian country, which means reservation boundaries, in light of McGirt? So those cases are happening on the ground all over Oklahoma. And of course, there's been new filings of new charges that have been brought after the McGirt decision. So that's, you know, certainly underway. Most of the tribes in this region have publicly announced that they have some sort of a commission that's created to deal with the mechanics on the ground. All of the tribes at issue, when I say the 5 big tribes in Oklahoma, they all have tribal courts. They've all got tribal attorneys. They've got judges. They've got court staff. So they're not going to have to invent anything new from whole cloth. They've got laws, they've got constitutions, but if they're going to see a lot more of these cases come to their courts, all of them realize that there's going to be a pretty steady incline in the increase the dockets. So it's a question of growing that docket size and then working out the minutia in a positive way with all of the county, state, law enforcement, social workers, you know, everyone that you can think of in first responders. But if there's a place where this can happen and happen well, I think it's Eastern Oklahoma. You know, and I say that because this bombshell type case is not new to us. Oklahoma had exercised criminal jurisdiction everywhere inside our boundaries, including on lands that are still held by the tribe in a restricted status. And in the 1970s and 80s, the courts finally said, no, you can't exercise jurisdiction on these pieces of restricted tribal property. And so that kind of led to this genesis of the creation of modern day tribal courts. And at that time, a number of cross-deputization agreements are entered into so that when a 911 call happens here in Cherokee Nation, the first responder, whoever hears it, is going to go to that, you know, scene of the crime. They're going to deal with the public safety issues. They're probably going to make an arrest. And the way that it works out with these agreements is that if a Cherokee, you know, law enforcement officer arrests somebody that they couldn't prosecute themselves, then they hand them over to the state and vice versa. So there's a lot of mechanics that are already on the ground. They maybe need to double in the number of those agreements. They might have more details that need to be worked out. But that's one of the things that's so frustrating for me in the day-to-day pushback here in Oklahoma. You know, Oklahoma spent 100+ years exercising jurisdiction that they legally had no authority to do so. They're not just going to give in the day after that Supreme Court case and say, okay, right? And so at every step, there's some pushback. But then in all fairness, at every step, there's been remarkable cooperation across the state. And so, you know, you've got state judges calling tribal court judges, I've got this many cases, I'm not sure how to proceed, what do you think we ought to do? Same thing with law enforcement. And, you know, all of these courts and the tribal judicial systems are, you know, staffed and led by highly competent attorneys, just the way that the district attorney's offices are throughout the state. Most of these people probably went to law school together, or they're related somehow in their families, you know, so it's not quite the parallel universe that is described in the media. On the ground, people are trying to do everything they can to ensure public safety, and most people are acting in incredibly good faith in doing so.
That's great. So tell me about the, like, were there any surprises coming out in this decision? Rebecca, you talked in This Land about Ginsburg's, like, honest, I was sitting around waiting and wondering, you kind of opened your eyes to that and some of her past decisions regarding Native American issues. Were there other surprises, anything enlightening or infuriating, interesting came out of this 5-4 decision?
Yeah, I mean, I think it's, you know, telling that it was, you know, it's a case where the law is very black and white, but it was still decided by just one vote. And I do think, you know, Ginsburg, her track record on Native rights is very mixed. So in the times that tribes have lost in that, you know, not so great win-loss record that I talked about earlier, and the majority of those times Ginsburg has been in the majority. So she has ruled against tribes a number of times. She also wrote the Sherrill decision, which a lot of people say is one of the worst decisions for land and treaty rights in 20 years, 50 years, depends on who you talk to, but it was pretty terrible. And so there were a lot of reasons that people were concerned about Ginsburg going into this. I mean, it's kind of ironic. I think a lot of the headlines were about how Gorsuch, you know, this shocking moment that Gorsuch sided with all of the other liberal justices. And I think people who are familiar with the court and familiar with Gorsuch, like, we knew Gorsuch was gonna be on our side. The person that we were watching was Ginsburg. But I'm glad that she joined the majority, and we needed that vote to win, and for Muskogee Creek Nation to have their land affirmed. I think what is concerning, and again, like with it just being right on that hair of it being that one vote, is when you read the dissent, if that had been the majority opinion, it would have not only been a huge loss for Muskogee Creek Nation that has already gone through the trauma of removal, of losing their homeland, of allotment, but I think it would have been pretty damning court precedent for all of Indian country, because what the dissent did is, you know, there's this well-established test of when we know that there is a reservation or not. And it's basically that Congress puts it in writing, you know, lo and behold, just like any other area of the law, we expect Congress to put it in writing. And the dissent did all of this mental gymnastics to get around that hard and fast rule and create all of these other reasons why Muskogee Creek Nation no longer has a reservation. And I think that that precedent coming out of the Supreme Court would have not just been devastating for Muskogee Creek people, but I think for treaty and land rights nationally, it would have been really scary. You know, I mean, the first paragraph of what Chief Justice Roberts writes, I mean, I would summarize as just being like, I mean, you know, this hasn't been acknowledged for so long. It's a joke to think that it would still be reservation. You know, you can't possibly, you know, I think he uses language like it's absurd to think that it would still be a reservation, even though that's what the law says. And so, you know, and we've had so many court cases that have done that. You know, when the Supreme Court decided that tribes no longer have jurisdiction to prosecute non-Indians, that didn't come from anywhere. Like, there's not precedent. There wasn't anything that they based that on other than tribes' inferiority, really, and racism. And so we see these cases come up again and again, and that's what we would have gotten if the 5-4 had gone the other way. And I think, you know, instead of having this victory that we can use to build back Indigenous land and treaty rights, it would have been another moment that would have eroded that.
I want to add one quick thing in here, and it's in response to one of the questions in the Q&A chat. And the question was, do you think that Gorsuch gave his liberal colleagues a tutorial on Indian law to get them, especially RBG, to see the case in this way? You know, I think that any of the justices that have been on the court for quite some time, they slowly become more familiar with it. But I think that it punctuates the fact that as far as I can tell, in the entire history of the United States Supreme Court, there has been one tribal citizen that has been a clerk to any of the justices. And, you know, that is dangerous and disturbing on very, very many levels. But it's, you know, it's not lost on me that Justice Gorsuch spent so much time on the 10th Circuit, and that he's the only justice since O'Connor that spent most of their time west of the Mississippi. Mm-hmm. So I think that, you know, Justice Sotomayor got a lot of critique in her book and in her lecture series by acknowledging the fact that every justice on any court is, of course, biased in their own rights. And though we try everything that we can not to be, that we're still the product of our surroundings, of our reality, and of our life. And so I think that, you know, when his nomination was before consideration in the Senate, the tribes were in support because they had read his decisions, and they knew at least that he had the familiarity of their condition and their legal rights. And so a lot of the commentators have been puzzled by what a strange bedfellow of an alignment that this case was. But it's the third treaty rights case since he's been on the bench that he participated in, the first one that he authored. And I think what we are seeing is a slight change in the Supreme Court, at least as it relates to interpretation of treaty rights cases. They're not radically different, but there is a shift in the direction of looking more at how the tribes would have understood it and not raising these estoppel or equitable type arguments about you waited too long to bring this. With the tribes in Oklahoma, of course, they waited too long to bring some of these claims. One of the things in Rebecca's ancestors signed treaty in 1835 was this delegate to the United States Congress that was negotiated. And the same thing, people say, why did you sleep on your rights for so long? But most people don't realize that the crushing hand of the United States on Indian tribal sovereignty has been so profound for so long that it was during my lifetime that the United States lifted their prohibition of us actually having our own elections and electing our own tribal chiefs and tribal leaders again. And so, I like to tell people, as a kid of the 1970s, I grew up with the modern day tribal governments. And it's true, because just like they had to do after removal, they had to start everything all over again on that history.
Right. Well, I think it's a great reminder that our kind of superficial or even pop culture opinions about the Supreme Court and who sits on the Supreme Court are probably pretty, superficial, and that any justice is more complicated, and their decisions over a whole career are going to be more complicated than what we might think on the surface.
Yeah. So. And if I can add something, I think that, Native Americans tend to vote democratically, but I think it's really tricky, I think it also varies really widely regionally. And if you look at who our biggest advocates are in Congress, they are elected Native people like Deb Haaland and Sharice Davids, but they're also people like Tom Cole. They're also Republicans that will sometimes go to bat just because they know that they need the Native vote, like Murkowski or McSweeney. And so I think that there's a way that not just in the Supreme Court, but broadly, that Native issues don't always follow party lines. And can be quite complicated. And one thing too I wanted to add is I think that it's one thing that I hope can shift, and one of the reasons why I care so much about federal Indian law, but from the perspective of a journalist, is because I think the same ignorance that we see just in average people, you see show up in elected officials and judges. So last January, I sat in the courtroom while the Fifth Circuit heard a very important case that not only has to do with the safety of Native children and Native families, but really the entire legal structure defending Native rights, this case that's coming out of Texas right now. And you know how judges, they'll just come up with hypotheticals to be like, okay, well, if we ruled this way, could X, Y, Z happen? And one of the judges, trying to search her brain for a hypothetical about Native Americans, came up with this story about there being so many drunk Native Americans all over the place, driving off the reservation, that there needed to be special laws about it, and would that violate, the Equal Protection Clause? And so literally that was her go-to, was that extremely racist stereotype. And she felt comfortable, I was not the only Native person in the room. There were leaders from NCAI, from 5 different tribes. The tribes were intervening. They were party to the case. They were making arguments. And so in front of this room full of Natives, she felt totally fine saying that. And that was not the only extremely ignorant and offensive comment of the day. And, we see that a lot of times, when you listen to these arguments, judges and justices not just knowing the basics of federal Indian law. And I think that that's why it's important that we have a public that educates themselves, because if we don't have a voting citizenry that's, putting the people in the Senate and putting the people in the White House, who nominate the people, who vote on the nominations, you know, who pass the laws, who craft the legislation. You know, if we as citizens who are putting those people in power don't even know what a federally recognized tribe is, or, you know, that treaties are the supreme law of the land according to our Constitution, and that's what our United States Constitution says, then I don't think we can expect to have leaders that have that same base of knowledge. And so, yeah, and so I think, just circling back, I think Justice Gorsuch's opinion, I think it is kind of a little bit of a lesson. And I think he wrote it that way, or I surmise that he wrote it that way, knowing that he was filling in a lot of information for people that didn't have it.
That's great to know. So moving on, even from this, what do you two see as what's on the horizon for in terms of Native American rights, civil rights, and what are some of the most pressing issues right now? And what can we do? What can we do to help and support, and besides elect leaders who agree?
Well, and I'll start just with that. Everybody in the United States, regardless of political affiliation, talks about this being the most important election that we've ever seen. That couldn't be any more true for Indian country and Native advocates. So mobilizing the Native vote, and not just in the top ticket, but downstream as well, is going to be really critically important. I think that if anything, this case shows that for federal Indian law, things that lawyers have already known, and that is how precarious the balance is on that Supreme Court right now. It's not just McGirt and the last two treaty cases since Justice Gorsuch has been on the bench. The last case that dealt with whether a tribal court could hear civil cases with a non-Indian sex offender on their reservation through civil lawsuits as opposed to criminal lawsuits. That was decided in a case called Mississippi Choctaw versus Dollar General just a few years back, and it too was a 5-4 decision. So political, it's political season all the way around, and tribes are very savvy and able to participate significantly in that process. So that's the number one thing on the agenda. I think that this case will get tribes to stop being as worried about advancing some of the claims as they have been. Prior to the last 5 years, the 40 years before it in the Supreme Court was probably the worst time frame for Indian country in the United States Supreme Court since the turn of the century. Case after case after case was lost during the Rehnquist court time. So I think that everybody will maybe be a little bit more strategic about going ahead and advancing those claims in light of McGirt. And that will be, treaty cases, it'll be jurisdictional cases, it'll be regulatory cases. But I think that we will see a little bit more activity. And I think that McGirt will also maybe lead to some more intergovernmental agreements where states can, states and tribes can look at situations and say, do we really need to go to court over this, or is there a way that we can enter into agreements that make sense in our small communities to make this happen? So I think that we'll see a lot of that. And I think what happens in Oklahoma on the ground right now after McGirt will be very instructive to that. And then I think right now, the takeaway for me is that here's this 5-4 decision, and all of the justices uniformly agree that Congress can just take this away overnight and that they have the power to do so, right? And we still live in a situation where what you see at least articulated on the international scene for Indigenous rights, which would preserve boundaries, which would preserve tribal languages and tribal autonomy. In the United States, we're still living under something called congressional plenary power that says, as long as they're express in doing so, they can do everything they want to take away power tribes. And that would include even saying this particular tribe is no longer federally recognized anymore as a political entity. We recognize nothing. So yes, it's a victory, but it's a victory in a very flawed area of the law, and a very complex and flawed one at that.
So Rebecca, what do you think? What are the pressing issues for Native American rights, and what can we do to advance them?
Yeah. I mean, I think it's been 2020, I think will be a year in Native history that we talk about for a long time. I think we've had some really important victories. This McGirt case, some rulings, although they were quickly reversed around pipeline cases. And then also the Washington football team finally changing their name. And so I think some of that, I think has to do with the broader racial reckoning and the momentum of Black Lives Matter. I think particularly some of the racist mascots and monuments that affect Indigenous people that we're seeing finally taken down, I don't think would have happened without that. And then I think some of it is, because of the work that Native leaders have been doing for decades. I mean, we didn't just happen to have good representation at the Supreme Court. Native leaders were looking at the Supreme Court and saying, we are losing right and left, and we don't have Supreme Court practitioners that understand federal Indian law. And so, Riaz Kanji didn't just stumble onto this case. He worked with leaders at NCAI, he worked with Gershengorn, and they worked to sort of build up that practice that hopefully will continue to support tribes and benefit all tribes. But, one thing I'm kind of excited to see grow out of the McGirt case, and what I hope we can model here in Oklahoma, is what restoring tribal jurisdiction and tribal sovereignty over treaty territory looks like. Oklahoma isn't the only state or the only place in the United States where a tribe does have the treaty rights to land, and it's either not recognized locally or not recognized nationally. There are lots of other examples, and I think there's this panic that if we restore tribal jurisdiction, the parade of terribles will come along. And so, yes, that's what the law says, and yes, that's what the treaty says, but could you possibly, we can't possibly do that. And so I hope that what McGirt can do is model that transition to restoring tribal jurisdiction or restoring tribal sovereignty where it has not been recognized, even though it was there the whole time, is actually a really manageable transition. And then I think we also need to talk about, there's sort of this hashtag that I saw a lot of people use when the McGirt decision came out. And I feel kind of complicated talking about it in this context because nothing was given back to Muskogee Creek Nation. It was their reservation all along. But people, I think Indigenous youth started it in Canada, but there's this hashtag called Land Back that now, on Twitter and Instagram, a lot of Native people are using. And I actually do think that that's one, I think what Stacy brought up, were sort of the box that tribes have been put in, going back to the doctrine of discovery, going back to the Marshall Trilogy, the foundation of federal Indian law is extremely racist. The legal framework that Europeans could just come and take this land because non-Christian heathens have no rights is still actually is the framework that we're working on. And so I do think that there needs to be that change. And then I think we also really need to talk about, what is public land management? What does our whole national forest and national park system was built on theft from Indigenous people, and so what does returning the management of some of those lands back to tribes look like? We're in this moment where the West Coast is on fire, and the tribes there, climate change is, of course, contributing to it, but the tribes there also had a practice of doing controlled burns to prevent that type of crisis. And because we have a century where those tribes have not been allowed to do that practice in those forests, we have forests that are a matchbox. And so I think that we need to reframe how we think about I hate to use the word return, because it's not return. You can't return, like it'd be like I came over and stole your television and then be like, hey, look, I'm returning it. But when it's been yours the whole time. But I think we need to have a broader conversation about what restoring tribal sovereignty and tribal jurisdiction looks like. You know, one of the things that I was really excited to see be on the platform of multiple Democratic candidates was an Oliphant fix. Which was the really terrible Supreme Court decision that said that tribes can't prosecute non-Indians. And it's been devastating for public safety in Indian country. And so I think, I think there's a lot where, you know, we need to get back to the inherent rights that our nations have over our lands, over our citizenry, over our language, and over our culture. And then also think about, you know, what is a vision of the United States moving forward, where we think about restoring land to the jurisdiction of tribes.
That's great. Well, before we move to questions, I'm gonna switch gears just for a second. You both moved away from Oklahoma and you went other places and you did other things, and now you're both back, and you're really invested in the Cherokee Nation and in Native American rights advocacy and that kind of thing. So I'm wondering if you have similar or different stories about how do you went out there in the world and then you came back. So what does it mean to come home again? Stacy, I'll put you on the spot.
Okay. Well, I guess my answer would be I've never really ever totally left. So I don't see it as coming back. I see it as always maintaining, these ties. So I mentioned my son's 7th generation of people after our removal to be here in this area. And I went away to undergrad, came back for law school, went away to work in North Dakota and Wisconsin. But when I had the honor and privilege of serving on the Cherokee Nation Supreme Court back in the early 2000s, I actually relocated and lived here in Tahlequah, and then just flew up to North Dakota to teach, and during the week I could come back. So it's been a long-term commute. And I did the same during the 7 years that I was at University of Kansas. And one of the things that was so attractive to me about the opportunity to build a career in Fayetteville was just the proximity. I can be door to door from downtown Fayetteville to my house here on the river in an hour and 15 minutes. And so the timing has worked out really well for me and my family. My son was able to start the 7th grade over here in the Cherokee Nation Language Immersion Charter School. And so unfortunately it's still online due to COVID, but he's doing it from his room here in Tahlequah. And I thought it was very important that I was able to give to him the kind of thing that I had, and that I grew up around a whole lot of Cherokee and Muskogee Creek people in Muskogee, Oklahoma. And so, I probably will go off and do something else again at some point in short intervals, but this will always be home. And, there's very, something entrenched in a cognitive and spiritual place for me to be here.
Mm-hmm.
Yeah. So Rebecca, you went to Baltimore to college, and you were in Baltimore in arts advocacy, and then came back, right?
Mm-hmm. Yeah. So I went to school in Baltimore and graduated, and then stayed and was pretty involved. I did community organizing in Central West Baltimore, worked with an art and advocacy project that focused on building support for survivors of rape and domestic violence, and was really involved in the Baltimore urban Indian community, which overlaps a lot with the DC community, and even like the Virginia and Pennsylvania community, and had actually like pretty big roots there that I did not think that I would let go of. And then, I think for personal reasons, I was just in a place where I wanted to live closer to family and see them more frequently. And then also this opportunity came up to work for my tribe in the Master Apprentice program. And I was in a place where I could do it, which seemed like a very rare opportunity. And so I sort of made the leap and moved to Tahlequah, and am still here. So yeah, I think that, you know, Cherokee Nation we're a lot of different things. You know, we're a government, we're a culture, we're, you know, 380,000 something citizens, but I think we're also a place. And for me, like living here, I feel much more connected to the tribe and to being Cherokee. And so I have been really grateful for that move.
That's great. Okay, I'm going to move to a couple of our questions we have here, and two of them are I think, similar and can be combined. From David, Mark, and Elnora Cameron. Are you worried, or what are the prospects? What's happening in terms of Congress, and the Oklahoma delegation in Congress was immediately talking about overturning and creating new law. Do you have any predictions, or what are the rumblings around what's happening in Congress, and could they undo all of this?
So I'll start with, yes, they could undo this. And, you know, there's significant fear that that might happen. There is mixed opinions on how fast that could happen or whether it would actually happen. But one of the, I think, best things that has happened in a long time is when this case came out and there was some talk about congressional action, whether that was by agreement with some of the tribes or not. I never in my lifetime have seen tribal citizen engagement in these 5 tribes to the magnitude that I do right now today. And so, you know, the outtake is, I think a lot of communities are taking this very seriously and taking any threat to this very seriously. And I will punt it to Rebecca to talk about what she's hearing on the legislation. One of the things I'll mention is shortly after the McGirt decision came down, I began being one of 3 district court judges for the Muskogee Creek Nation. And so they're very similarly situated, but also differently situated than the other tribes. So I have one opinion as a Cherokee Nation citizen, and then I have no opinion as a judge of the Muskogee Creek Nation. And so I'm going to take a punt and let her handle the rest of this.
Okay.
Yeah, so it's complicated. A lot happened, and a lot happened very quickly after the decision came down. So one of the things that happened was that there was an agreement in principle that was basically kind of like an outline, I would say, of possible legislation that Congress would pass that supposedly the 5 tribes and the Attorney General agreed to. It disintegrated within 24 hours. So Seminole Nation put out a public statement, and then shortly after that, Muskogee Creek Nation, which is the tribe that was at the center of the Supreme Court case, also said that they were opposed. And Muskogee Creek Nation's official position now is that they're opposed to any congressional legislation, and they don't feel that any legislation is necessary. I think maybe like the agreement in principle came out on a Thursday. I think by Monday, Chickasaw, Choctaw, and Cherokee Nations had also hit the pause button. And I know that some possible legislation has still been talked about. But from sort of the sources and the people that I'm talking to, nobody has like seen a bill. And so one of, I think that what Stacy was talking about, where there was a lot of engagement in tribal citizens, I think that you saw with the agreement in principle, and people, you know, it was extremely unpopular with tribal citizens, and people sort of, you know, raising up and protest against it, was how important sovereignty is to tribal citizens. And I think after this historic victory, Oklahoma learned that its tribal citizens are going to do everything that we can to protect it. The other thing that happened that honestly has just been rumor, and when asked about it by reporters, Inhofe denied it, but there was a rumor that got a lot of traction. I think NCAI even put out, an official statement that they would propose any congressional legislation, was that Inhofe would introduce a rider and try and attach it to a bill. So maybe like a defense bill or something where he would try and sneak it in. And he actually did that back in, I think 2005, but in the early 2000s, he snuck something sneaky that diminished tribal civil authority over environmental regulations into a transportation bill of all places. And so there's been a lot of fear about that. I think that there is a good reason to doubt that a democratically controlled House that has strong Native leadership would pass a bill that disestablished the reservations. And I also think that there's a lot of reason to doubt that a Republican Senate would do it too. You've got people who are running for re-election who need the support of tribes, like McSweeney in Arizona, that aren't going to go for a bill that is going to upset the tribal citizens whose votes that they need. And so I think that that is, I guess one of the strengths of, the way we were talking about earlier, how politics in Indian country doesn't necessarily follow party lines, is that when it comes to these bills being talked about, we actually do have allies in both parties. And so, I think, I think that Muskogee Creek Nation is doing a really good job of leading, some of the issues that do come up, leading the charge through making intergovernmental agreements. So one of the things is a change in like child welfare proceedings, and they did an intergovernmental agreement so that Oklahoma will continue to do cases so that there aren't kids that are just left in dangerous situations, but it's a stopgap measure so that the tribe can build up that infrastructure to handle that caseload that it hasn't had because we've been divested of jurisdiction, And so I think that measures like that, intergovernmental agreements, are a great way to move forward. I think what's scary about any congressional legislation, even if it was something that in some ways maybe strengthens tribal sovereignty, is that once you sort of open it up to Congress, you sort of become vulnerable to other things getting put in there. And so, we have the treaty rights, the courts are sort of sorting out now exactly what it means for the other 4 tribes. But I think if you look at sort of the facts on the ground and sort of this bigger question of, is congressional legislation necessary, which I think a lot of people who are raising all these fears are trying to say, Stacy wrote that opinion piece for Slate about how the sun came up in Tulsa the day after the McGirt decision, and we're here in September, and the sun has come up a bunch of times since then. And so, we've already been living with the ramifications of this case for months, and we're all okay. And I think that's going to continue to be the case.
So there's a really interesting connection here. Somebody's brought this up related to exactly something you were just talking about. When Kenneth Starr was Solicitor General, didn't he try to abolish all tribes except for the Hopi and Navajo? And of course, Ken Starr, stars in the Clinton story. And so funny that there might also be a connection here. Do either one of you remember that or know anything about that?
I don't specifically with Ken Starr, but there's certainly been times, the 1940s and 50s in particular, where it has been stated federal policy to terminate tribes. So the fact that 1 or 2 people may have opinions in that direction, it certainly has been the case that there's been a lot more steam behind that in the past. And I think some of those histories are what informs the, concern throughout Indian country that something might happen here again.
Interesting. Well, we have a question too that will require a little context for some of us. Has there been any progress for Kim Teehee being seated in Congress? So we're going to need to know who Kim Teehee is, and then what you have to say about that.
Yeah, I can start with the background, and then Stacy, you might know more about the current developments. But in two treaties, the most recent of which is a treaty that my ancestors signed, the Treaty of New Echota. We have the treaty right to a congressional delegate that would represent Cherokee Nation in Congress. That treaty right has never been fulfilled by the United States. And our chief now, Chuck Hoskin Jr., our principal chief, pretty soon after being elected, appointed Kim Teehee, who also does government affairs and government relations to our tribe, to that position. And so what's left is for Congress to seat her and to fulfill the treaty obligation to Cherokee Nation. And Stacy, I'll let you fill in the rest.
Yeah, the interesting thing about that, so there's the two treaties that Rebecca mentioned, but then there's the other treaty, the 1866 treaty, which basically says, unless there's conflicting terms between this treaty and prior treaties, all of those prior promises continue forward. And so that 1866 treaty was the companion treaty that was just at issue with the Creek Nation and is at issue in various courts with the Cherokee Nation as well. And so, you know, this is one of those rights that the tribe is advancing in the 2000s, and part of which is, I described this issue of not being able to elect your own leaders. But I am constantly amazed with the foresight of our ancestors and what they insisted on in terms of legal language to go in certain things, that it might take 100 or 150 years for those to come to fruition, but the forethought was there. And so, you know, the reason that it was mentioned twice in those early treaties is that one time it said a deputy to Congress. And then when the United States Supreme Court heard a case in the early 1830s, they said, well, that didn't really mean a delegate, it just was like at the pleasure of. And so then in the next treaty, in 1835, they made it crystal clear that it's not a deputy or a diplomat, it's an actual, you know, representative to Congress. And that person, should Kim be seated, would have the same status as, say, the Mariana Islands and some of the United States protectorates that aren't full voting members of Congress, but have floor access and whatnot. And so that's what the push was for. In the 1970s, when the Cherokee Nation was just rebuilding, there was a new constitution at that time, and it didn't mention anything about the delegate, but it said, you know, we're rebuilding, and what we're going to do is provide for a constitutional convention to happen every 20 years to see if there's a moment to reinvent ourselves at that time. So there was a constitutional convention held for several days in Cherokee Nation in 1999. And at that time, the provision got put into our current constitution that says that the principal chief shall put a delegate forward for Congress. So this was not something that our current principal chief just did on his own, but it's constitutionally required that he do so. Mm-hmm. And so after the other provisions in the Constitution were carried out, albeit this is one of the later ones to come to fruition, but it was, you know, history brought into the present, and now we're in the process of seating her. So she's the designate, and she will be seated when Congress makes provision for that. That could probably happen one of two ways. One, that it would require an actual act of Congress that both houses would play a role in, and that would be signed into law by the president providing for that. Or there's an argument that the House of Representatives, just in its procedural rules, might provide for that. So needless to say, there's lots of discussions going on in DC, but we wouldn't anticipate anything happening before this election.
Mm-hmm.
Okay, that's interesting. Well, somebody else commented, and this kind of brings it all back full circle as we kind of come to a close here. My friend Lauren noted that Stacy, your son, having been in the Fayetteville public schools, now is getting to have this different kind of educational experience. And Rebecca, you may not know this, or anybody who's not from here in Fayetteville, but Fayetteville Public Schools just went through a name change of its junior high. They were the Woodland Cowboys and the Ramey Indians. My son was a Ramey Indian a few years ago, and it bothered me then. And this even happened before all the other kinds of upheavals we had this summer, but Fayetteville was taking a close look at that. And I don't even know, I don't remember what names they ended up changing to actually, but it is interesting that, Stacy, that your own child would have these two kinds of experiences.
Mm-hmm. I'm really proud of what happened with the Fayetteville Public Schools on this issue. I was, right there in the middle of it. I chaired the commission. There were 17 people, students, parents, alumni, principals of the two junior highs. And I was really pleased before that Rebecca brought up the Washington football team,
Yes.
because I mentioned that there's only been one tribal citizen to ever clerk for the United States Supreme Court, and just this notion of complete invisibility that Native people feel here in the United States. And, going through that process with that committee and hearing all of the comments and all of the dialogue in our community there in Fayetteville, that was a personally painful process for me. Sometimes even, taking a then 10-year-old to Fayetteville Public School meetings, and, have people say things that then you need to debrief for 3 hours in the car, and at home when you get there. But it was a step that had to happen. But I think that it dovetails perfectly well with what we've been talking here tonight, because when we live in a society that is so immersed in inhumane imageries toward a group of people, to the extent that those people become invisible and cartoon character-like, and unless you personally know somebody, it doesn't occur to you how hurtful, that can be to a little kid, or, to people in general. But I think that it is part and parcel why the people in Oklahoma right now, many of them who are just shocked at this decision, and they are fearful of tribal courts because they don't understand that the, tribal judge went to the same law school as the state court judge, but there's this feeling of tribal inferiority, and that they must have inferior institutions, and that they themselves can't be as biased and so, or unbiased in these decisions. So I do think that they're very interrelated, but I had wonderful experiences from K through 6th grade with my son there in Fayetteville Public Schools, and that change was kind of the last thing that occurred during his year in the 6th grade. And so I know that as an old man, he'll remember all of that. And it'll be a powerful part of his life, but he'll also know that positive change is possible, right? And people came together and did the right thing. But I do think that the imagery and the mascots absolutely are tied to people looking at Indian tribes and Indian institutions and thinking that they can't possibly be real, because they just don't have that experience. And to them, a Native person can't possibly be dean of a law school or a national recognized journalist, and that's something I think is really special about everything that's gone on in Fayetteville. There's so many back and forth ties, but that was just a painful thing that had to happen so that the education could continue in that school in a culturally appropriate way.
Absolutely. Well, that's beautifully said, and a great closing note. I think we're coming up on 8 o'clock. But if either of you have any last words or anything you don't think we touched on, you're welcome to do that now.
I just want to say thank you so much for organizing this, for thinking of including me, and for having this discussion. I think it's great, and I'm a huge fan of Stacy, so always excited to be in conversation with you as well. So this was just a really, really exciting evening and a great event. Thank you so much.
Oh, I'm so glad you guys did this, and it's also, I think, really special that we have these two women representatives too of all these from the Cherokee Nation and with these Fayetteville ties. I think that's pretty cool. So we have one question in the box that I'm going to send out when I'm going to email the recording to everybody who registered. So everyone will have that. And Jaden Atkins has asked if like what kinds of things they could read to sort of get updated on Indian law. And so I will look into that, and I'll send out some resources when I send the recording to everybody. So thank you both so much. Thanks everybody for attending. And I hope that we all get to see each other in person one of these days.
Mm-hmm.
Thank you. Good night.
Thank you.
Thank you.